Good afternoon, everyone. It is now 1:35 p.m. and we are back from recess. This morning, we had issued a subpoena on October 8th to have Ms. Frances de la Cruz appear before this committee. And um, subsequent to that, we issued another subpoena at 12:45 to expand the scope of the subpoena. And at this time, Ms. Frances de la Cruz, I understand, is in the chamber. Would you please proceed to the chamber? And her counsel, I'm sorry. May I ask who will be representing Ms. Frances de la Cruz this afternoon? Which counsel?
I will be representing Ms. De La Cruz.
Thank you, Ms. Viola Alapuzo, counsel for Ms. Frances de la Cruz, and welcome back. I also want to state for the record that Mr. Gil Bernberg, the legal counsel for the governor, is with Ms. de la Cruz as well, sitting to her right. Welcome again, Mr. Bernberg. Ms. Frances de la Cruz, may I ask you to please stand, rise, and raise your right hand to be administered the oath?
Chairwoman, before we proceed with that, if I could be allowed, just for the record, this morning, the committee read into the record two letters, one from me that was emailed this morning at 1 a.m. and another one from Mr. Burnbridge. However, the committee did not address a November 11th letter that I emailed on November 12th to you and to your counsel, Mr. Tyrone. In the letter that was read this morning, it specifically said that this is a supplemental to the November 11, 2021 letter. So I'd request that if those two letters this morning are to be made part of the record, that the November 11, 2021 letter be also made part of the record, because you can't understand the letter from this morning without having the November 11th letter into the record.
Noted, and that will be a part of the record. Cam, can we have an exhibit number for that? Short recess. Thank you. We are back from recess, and before we went to recess, Council Viola Alapuzzo asked that a November 11th letter from her to the committee be entered into for the record, and we have agreed to do so. It is up here on display on the Elmo, and that is now entered as Exhibit 78. Thank you, Mr. Nicholas. Moving along, also prior to the recess, we had asked a witness to stand up and take her oath. But before we do that, we just wanted to clarify, Mr. Burnbrick, may I ask what your role is? If Ms. Alapuzzo is the counsel on record for Mr. Cruz, may I ask what your role would be in these proceedings? May I ask you to please use the microphone?
Apologize for that. Uh, Ms. Frances de la Cruz is an employee of the Office of the Governor, and I'm here to assist Viola and Ms. de la Cruz here before this hearing.
You'll be co-counsel? I don't understand exactly what the role is. Would you like to comment to that, Ms. Alapuzzo?
Yes, thank you, Madam Chairwoman. The reason why Mr. Burnbridge is here is because, and also we'd like to request an opportunity for Mr. Garber to be allowed or to be given the link so that he could also join this meeting. And the reason why is because there have been issues raised by both Mr. Burnbridge and Mr. Garber on behalf of the Office of the Governor about executive privilege and testimonial immunities pursuant to the Constitution under the separation of powers doctrine. Because they've raised that, their presence here is necessary. Those are still issues that have been unresolved between the committee and the executive branch, as was explained in my November 11th letter. And I wanted to request from the chairwoman, because those other letters were read into the record, the public knows what those letters said, in order to have an understanding, a holistic understanding of what's going on. I think it's important to also read the November 11th letter into the record and not just submit it into the record. The public has not been given an opportunity to be informed of what it says and to lay out the issues that are before the committee this morning or this afternoon.
Thank you. This hearing was supposed to start at 10:30, and in the interest of time, we only have about 2.5 hours. It has been entered as requested into the record, and we will leave it that way for now. But I still don't understand, like I said, what exactly would Mr. Burnbrick be doing? Recognize I'm sorry, Ms. Viola Lapuzzo.
Okay, thank you, Madam Chairwoman. As I previously stated, the issues that Mr. Burnbridge and Mr. Garber has raised before the committee has yet to be resolved. As was stated in my letter in both November 11th and November 16th, that puts Ms. De La Cruz in a quandary. She's in a difficult position because her employer has raised privileges and immunities that has not yet been addressed or resolved by the executive branch and the committee. Mr. Garber and Mr. Burnbridge are here ready to speak on that particular specific issue. Now, with regards to advising Ms. De La Cruz as the executive assistant to the governor, that's my role as her counsel. But Mr. Burnbridge and Mr. Garber are here on behalf of the office of the governor, the executive branch. Thank you, Madam Chair.
Thank you, Ms. Alapuzzo. If that were the case, this issue of immunity and testimonial immunity was not raised when Ms. Keiko Rosario was subpoenaed to this chamber. And she is also an employee of the governor, in fact, more senior than Ms. Frances de la Cruz.
May I address that, Madam Chair?
Certainly.
Okay,
And then we move on.
all right. Um, Thank you for raising that issue with regards to Ms. Keiko Rosario. Ms. Keiko Rosario's testimony happened before Mr. Garber was retained by the office of the governor. I am not an expert with regards to legislative proceedings. And just like a doctor, if you don't have an expert on island, you go off island to find that expert. The office of the governor found an expert on these matters. They raised the issue of these privileges and immunities on behalf of their employee. Now, my responsibilities as their counsel is if something is raised to me and there's merit to those issues, then I too must raise it. Was I aware during the time that Ms. Keiko Rosario testified that she had executive privileges and immunity? No, I was not. But as soon as I became aware, I raised it on behalf of Ms. Dela Cruz because she was the one that was subject to the subpoena before this body then. Thank you.
Thank you. We will move on. May I please ask Ms. Frances Del Cruz to rise and be administered your oath by our counsel.
Ms. Dela Cruz, do you solemnly swear, under the penalty of perjury, that the testimony you shall give in the matter at hand shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may be seated. We will proceed. At this time, I would like to recognize Representative Blas Jonathan Attal.
Thank you, Madam Chair, and good afternoon, Ms. De La Cruz, Council Alifuzo, Council Burnbridge. Welcome to your chamber. Should start off with some preliminary questions, Ms. De La Cruz. Please state your name, your full name, and position for the record.
I, Frances Dela Cruz, hereby object to the subpoena served on me today, November 16, 2021 at 12:42 p.m., less than 1 hour ago because of the following. Number one, the subpoena must comply with 1 CMC Section 1302A, subpoenas, notice to witnesses. A is service of a subpoena requiring the attendance of a person at a hearing of an investigating committee shall be made at least 5 days prior to the date of the hearing unless a shorter period of time is authorized by majority vote of all the members of the committee in a particular instance when, in their opinion, the giving of 5-day notice is not practicable. But if a shorter period of time is authorized, the person subpoenaed shall be given reasonable notice of hearing consistent with the particular circumstances involved. Number two, I object to this subpoena because my employer and I have raised testimonial immunity, executive privilege as provided under the constitutional separation of powers doctrine. Number three, the subpoena is overbroad in that it seeks information unrelated to any official duties of myself and or the governor. Number four, the subpoena exceeds the scope of the legislative authority and power. Thank you, Madam Chairwoman.
Madam Chair, I know I asked a question and I believe the witness is providing a statement, correct?
Mr. May I please?
Recognize Council Alfonso.
Thank you, Madam Chair. Mr. Vice Chair, I believe what the witness did is not just provide a statement, but lodged her objections and stated the reasons for those objections.
Duly noted, actually, Chair.
Duly noted.
Thank you. Thank you for that, Council, and thank you for your statement, Ms. De La Cruz. Again, please state your full name and position for the record.
I, Frances Dela Cruz, hereby object to the subpoena served on me today, November 16, 2021 at 12:42 p.m., less than 1 hour ago because of the following. Number one, the subpoena must comply with 1 CMC Section 1302A subpoenas, notice to witness. A, service of a subpoena requiring the attendance of a person at a hearing of an investigating committee shall be made at least 5 days prior to the date of hearing unless a shorter period of time is authorized by majority vote of all the members of the committee in a particular instance when, in their opinion, the giving of 5-day notice is not practicable. But if a shorter period of time is authorized, the person subpoenaed shall be given reasonable notice of the hearing consistent with the particular circumstances involved. Number two, I object to the subpoena because my employer and I have raised testimonial immunity, executive privilege as provided under the constitutional separation of powers doctrine. Number three, the subpoena is overbroad in that it seeks information unrelated to any official duties of myself and or the governor. And number four, the subpoena exceeds the scope of the legislative authority and power.
Duly noted to your objection. I recognize Representative Blas Jonathan Acton.
Thank you again, Ms. De La Cruz. How many years have you served in this position?
I, Francis De La Cruz, hereby object to the subpoena served on me today, November 16, 2021, at 12:42 p.m., less than 1 hour ago, because of the following. One, the subpoena must comply with 1 CMC Section 1302A subpoenas. Notice to witnesses. A, service of a subpoena requiring the attendance of a person at a hearing of an investigating committee shall be made at least 5 days prior to the date of the hearing unless a shorter period of time is authorized by majority vote of all the members of the committee. In a particular instance, when, in their opinion, the giving of 5-day notice is not practicable. But if a shorter period of time is authorized, the person subpoenaed shall be given reasonable notice of the hearing consistent with the particular circumstances involved. Number two, I object to this subpoena because my employer and I have raised testimonial immunity, executive privilege as provided under the constitutional separation of powers doctrine. Number three, the subpoena is overbroad in that it seeks information unrelated to any official duties of myself and or the governor. Number four, the subpoena exceeds the scope of the legislative authority and power.
Privilege, Madam Chair.
Recognize Representative Tina Sablan.
At the risk of hearing Ms. De La Cruz's objection for yet the fourth time, can we clarify, did this committee take a vote and have a majority of the members approve the issuance of a new subpoena with an expanded shorter period of time, pursuant and in compliance with the law?
Madam Chair, may I please?
Recognize Representative Blas Jonathan Acton.
Thank you again for that, Ms. De La Cruz, and thank you, Rep. Tina Sablan. Yes, the committee did made a vote at 12 p.m. today, and I believe in Ms. De La Cruz citation of 1302A, she's missing the portion of she stopped at shorter period of time is authorized and skips that following or that same sentence and goes after the semicolon, but if a shorter period of time. But if you read the whole thing there, shorter period of time is authorized by majority vote of the members of the committee in a particular instance when, in their opinion, the giving of 5 days of notice is not practicable at that period of time. And we did vote at 12 o'clock this afternoon to issue the subpoena for Ms. De La Cruz. So I think, Ms. De La Cruz, if we're going to read 1302A and you're going to cite it for you objecting to the subpoena, I believe you should read the whole subsection A of 1302.
Madam Privilege?
Just one more thing. I also want to state for the record, the same statute that Ms. De La Cruz is citing under the same 1 CMC subsection 1308, cooperation of government officers and employees. The officers and employees of the Commonwealth shall cooperate with any investigating committee and with its representatives and furnish to it or to its representatives such information as may be called for in connection with the research activities of this committee. I want to state for the record that this portion of the statute is compulsory, not discretionary. So it is not an option for government employees not to cooperate with any legislative committee investigating, exercising their authority to investigate anything in the government. I will now recognize Representative Edwin Probst.
Madam Chair, I was just going to clarify, but you've already answered that. At this point, would it be possible to ask for a short recess?
Not a problem if there are no objections from the members.
No objection.
Short recess. Thank you. We are back from recess, and before we broke for the recess, Representative Probst had the floor. I recognize Representative Probst.
Uh, Thank you, Madam Chair. I yield at this time. Thank you.
Thank you. At this time, I would like to recognize Representative Blas Jonathan Atto.
Thank you again, Madam Chair, and welcome back, Ms. De La Cruz, Attorney Lepuzo, and Attorney Bernbrick. Welcome back. Again, Ms. De La Cruz, please state your full name and position for the record.
I, Francis De La Cruz, hereby object to the subpoena served on me today, November 16, 2021, at 12:42 p.m., less than 1 hour ago, because of the following. Number one, the subpoena must comply with 1 CMC Section 1302A subpoenas, notice to witnesses. A, service of a subpoena requiring the attendance of a person at a hearing of an investigating committee shall be made at least 5 days prior to the date of the hearing unless a shorter period of time is authorized by majority vote of all the members of the committee, in a particular instance when, in their opinion, the giving of 5-day notice is not practicable. But if a shorter period of time is authorized, the person subpoenaed shall be given reasonable notice of the hearing consistent with the particular circumstances involved. Number two, I object to this subpoena because my employer and I have raised testimonial immunity, executive privilege as provided under the constitutional separation of powers doctrine. Number three, the subpoena is overbroad in that it seeks information unrelated to any official duties of myself and or the governor. Number four, the subpoena exceeds the scope of the legislative authority and power.
Thank you, Ms. De La Cruz. As to your objection of having a majority vote by the members of this committee, if less than 5 days is practicable, we did vote at 12 p.m. today by roll call vote, and it was a unanimous vote to issue the subpoena that was served upon you at 12:42 p.m. today. So that objection is moot at this point. I will recognize Representative Blas Jonathan Atto.
Thank you again, Madam Chair. And Ms. De La Cruz, please state your full name and position for the record.
I, Francis De La Cruz, hereby object to the subpoena served on me today, November 16, 2021, at 12:42 p.m., less than 1 hour ago, because of the following. Number one, the subpoena must comply with 1 CMC Section 1302A subpoenas, notice to witness. A, service of a subpoena requiring the attendance of a person at a hearing of an investigating committee shall be made at least 5 days prior to the date of the hearing unless a shorter period of time is authorized by majority vote of all the members of the committee in a particular instance when, in their opinion, the giving of 5 days notice is not practicable. But if a shorter period of time is authorized, the person subpoenaed shall be given reasonable notice of the hearing, consistent with the particular circumstances involved. Number two, I object to this subpoena because my employer and I have raised testimonial immunity, executive privilege, as provided under the constitutional separation of powers doctrine. Number three, the subpoena is overbroad in that it seeks information unrelated to any official duties of myself and or the governor. Number four, the subpoena exceeds the scope of the legislative authority and power.
Your objection again is duly noted. I want to remind you of 1 CMC subsection 1308, cooperation of government officers and employees, and it reads in its entirety, the officers and employees of the Commonwealth shall cooperate with any investigating committee and with its representatives and furnish to it or to its representatives such information as may be called for in connection with the research activities of this committee. I will recognize Representative Blas Jonathan Atto.
Thank you again, Madam Chair. And again, Ms. De La Cruz, please state your full name and position for the record.
I, Francis De La Cruz, hereby object to the subpoena served on me today, November 16, 2021, at 12:42 p.m., less than 1 hour ago, because of the following. Number one, the subpoena must comply with 1 CMC 13, Section 1302A, subpoenas notice to witnesses. A, service of a subpoena requiring the attendance of a person at a hearing of an investigating committee shall be made at least 5 days prior to the date of the hearing unless a shorter period of time is authorized by majority vote of all the members of the committee. In a particular instance when, in their opinion, the giving of 5-day notice is not practicable. But if a shorter period of time is authorized, the person subpoenaed shall be given reasonable notice of the hearing consistent with the particular circumstances involved. Number two, I object to the subpoena because my employer and I have raised testimonial immunity, executive privilege, as provided under the constitutional separation of powers doctrine. Number three, the subpoena is overbroad in that it seeks information unrelated to any official duties of myself and or the governor. Number four, the subpoena exceeds the scope of the legislative authority and power.
Duly noted. Please answer the question.
I, Francis De La Cruz, hereby object to the subpoena served on me today, November 16, 2021, at 12:42 p.m., less than 1 hour ago, because of the following. Number one, the subpoena must comply with 1 CMC Section 1302A, subpoenas notice to witnesses. A, service of a subpoena requiring the attendance of a person at a hearing of an investigating committee shall be made at least 5 days prior to the date of the hearing unless a shorter period of time is authorized by majority vote of all the members of the committee, in a particular instance when, in their opinion, the giving of 5-day notice is not practicable. But if a shorter period of time is authorized, the person subpoenaed shall be given reasonable notice of the hearing consistent with the particular circumstances involved. Number two, I object to the subpoena because my employer and I have raised testimonial immunity, executive privilege, as provided under the constitutional separation of powers doctrine. Number three, the subpoena is overbroad in that it seeks information unrelated to any official duties of myself and or the governor. And number four, the subpoena exceeds the scope of the legislative authority and power.
Duly noted. Recognize Representative Blas Jonathan Atto.
Thank you again, Madam Chair, and thank you again, Ms. De La Cruz. Again, please state your full name and position for the record.
I, Francis De La Cruz, hereby object to the subpoena served on me today, November 16, 2021, at 12:42 p.m., less than an hour ago, because of the following. One, the subpoena must comply with 1 CMC Section 1302A, subpoenas notice to witnesses. A, service of a subpoena requiring the attendance of a person at a hearing of an investigating committee shall be made at least 5 days prior to the date of the hearing unless a shorter period of time is authorized by majority vote of all the members of the committee. In a particular instance when, in their opinion, the giving of 5-day notice is not practicable. But if a shorter period of time is authorized, the person subpoenaed shall be given reasonable notice of the hearing consistent with the particular circumstances involved. Number two, I object to this subpoena because my employer and I have raised testimonial immunity, executive privilege as provided under the constitutional separation of powers doctrine. Number three, the subpoena is overbroad in that it seeks information unrelated to any official duties of myself and or the governor. And number four, the subpoena exceeds the scope of the legislative authority and power.
Duly noted. I want to remind you, Ms. De La Cruz, that under 1 CMC 1306, a person shall be in contempt if the person fails or refuses to appear in compliance with a subpoena, or having appeared, fails or refuses to testify under oath or affirmation. Same statute, 1 CMC subsection 1306A2, fails or refuses to answer any relevant question, or fails or refuses to furnish any relevant book, paper, or other document subpoenaed by or on behalf of an investigating committee. At this time, I would like to recognize Representative Edwin Probst.
Thank you, Madam Chair. And thank you, Ms. Dela Cruz, for coming in today. It's good to see you and your councils. We appreciate your time. What is unfortunate is what's going on right now. You have been reciting your employer and reasons why you do not wish to testify today. It's just something that is quite confusing because every time we look at the newspapers or hear him speak on KKMP, your employer, Governor Torres, continues to proclaim that he has nothing to hide. Ms. Dela Cruz, we're not here to prosecute you. There's nothing here that should implicate you, as far as I've seen. Your reluctance to testify today, to speak to any of our questions, is disrespectful to the chair and to this committee. I'm stating this for the record. I do want to ask you, though, did your employer, Governor Torres, ask you not to answer our questions today?
I, Francis de la Cruz, hereby object to the subpoena served on me today, November 16, 2021, at 12:42 p.m., less than 1 hour ago, because of the following. 1, the subpoena must comply with 1 CMC Section 1302A, subpoenas notice to witnesses. A, service of a subpoena requiring the attendance of a person at a hearing of an investigating committee shall be made at least 5 days prior to the date of the hearing unless a shorter period of time is authorized by majority vote of all the members of the committee. In a particular instance when, in their opinion, the giving of 5-day notice is not practicable, but if a shorter period of time is authorized, the person subpoenaed shall be given reasonable notice of the hearing, consistent with the particular circumstances involved. Number 2, I object to this subpoena because my employer and I have raised testimonial immunities, executive privilege as provided under the constitutional separation of powers doctrine. Number 3, the subpoena is overbroad in that it seeks information unrelated to any official duties of myself and or the governor. The subpoena exceeds the scope of the legislative authority and power.
Ms. Dela Cruz, you obviously are not going to answer any of our questions that we have prepared today. And I want to state for the record that it is that I really sympathize. I sympathize with you. I sympathize for you for being used as a pawn by Governor Torres, who is so willing to sacrifice. We've seen time and time again that the governor has stated that he wants this to move expeditiously, and he is the one that is making this a complete mockery. If there are any delays, it is obviously coming from witnesses who are not even being implicated unless they are somehow guilty of something. But that is not why we're here. We're simply trying to ask questions in our investigation of your employer, the governor, which you are willing to risk contempt. I really I hope you reconsider this because this is a deep concern here. The penalties of contempt are severe. And if you have done nothing wrong, I don't see why you would even be willing to state your name or position. What has the governor said to you to make you so reluctant to answer any of our questions today? Did the governor threaten to fire you?
I, Francis Dela Cruz, hereby object to the subpoena served on me today, November 16, 2021, at 12:42 p.m., less than 1 hour ago, because of the following. Number one, the subpoena must comply with 1 CMC Section 1302A subpoenas, notice to witnesses. A, service of a subpoena requiring the attendance of a person at a hearing of an investigating committee shall be made at least 5 days prior to the date of the hearing unless a shorter period of time is authorized by majority vote of all the members of the committee. In a particular instance when, in their opinion, the giving of 5-day notice is not practicable. But if a shorter period of time is authorized, the person subpoenaed shall be given reasonable notice of the hearing, consistent with the particular circumstances involved. Number two, I object to this subpoena because my employer and I have raised testimonial immunity, executive privilege as provided under the constitutional separation of powers doctrine. Number three, the subpoena is overbroad in that it seeks information unrelated to any official duties of myself and or the governor. And number four, the subpoena exceeds the scope of the legislative authority and power.
Thank you. Your objection, once again, is duly noted, and I want to remind you, under the same statute, a different section this time, subsection 1307, penalties, defenses. A person guilty of contempt under this chapter shall, upon conviction, be fined not more than $1,000 or imprisoned not more than 1 year, or both. Subsection 1307B, if any investigating committee fails in any material respect to comply with the requirements of this chapter, any person subject to a subpoena or a subpoena ducis tecum who is injured by that failure shall be relieved of any requirement to attend the hearing for which the subpoena was issued for, if present to testify or produce evidence therein, and that the failure shall be a complete defense in any proceeding against this person for contempt or other punishment. Again, Ms. De La Cruz, you have objected to everything we have. We are simply trying to ask you simple questions such as your name, and you have repeatedly read a statement prepared for you as to your objections. And in your objection, you stated that the subpoena does not cover the scope of your work at the executive office. All the more reason why immunity does not apply to you. At this time, I will recognize Representative Tina Sablon, who is with us virtually.
Thank you, Chair, and good afternoon to you, Ms. Dela Cruz and Ms. Alapuzu and Mr. Burnbrick. My first question is actually for Mr. Burnbrick. I'd like to better understand your role in being in the chamber and sitting next to Ms. Dela Cruz if all she is going to do is read her statement of objection to all the questions that we ask. Why are you still there if that's all she was going to do today?
I am here to represent the interests of the office of the governor. If any issues come up, like regarding the immunity, anything like that, and I am here, I can be here to assist or argue. Thank you very much.
Okay, and is your role then to make sure that all she does is read her statement of objection, invoking those immunities and privileges?
Was she, Ms. Valapuzzo is her counsel. If Valapuzzo,
Right, but I'm trying to understand your role as the counsel for the governor. Are you there to simply make sure that all she does is answer our questions with her statement of objection?
I am not here as her minder. I'm here representing the interests of the office of the governor.
So I'd like to direct my next questions to Ms. Dela Cruz. I do sympathize, Dela Cruz, with you and the difficult position you're in. You must be under a lot of pressure. You are under subpoena, and you work for a governor who is under investigation. And sitting right next to you is his counsel. But you do have legal obligations to comply with a legislative subpoena and to cooperate with legislative investigation. And I'd first like to note that you've been under a subpoena issued by this body for several weeks now. And that was a subpoena that was quashed, and you were commanded to appear today at 10:30. And you failed to appear. And the second, the additional subpoena that expands on the first subpoena reiterates all the other subject areas that we wanted to ask you about. That subpoena is also valid. It was voted on by and approved by the majority of members in a public meeting of the legislative committee and served upon you. And the vote was taken to issue that subpoena, provide a shorter period of notice compliant with the law. And so you have appeared, and we appreciate your appearance, but refusing to answer questions is also grounds for contempt, as the chair has noted. And I guess my first question to you is it your intention to refuse to answer any of our questions today?
I, Francis De La Cruz, hereby object to the subpoena served on me today.
Okay, thank you. Privilege. We've heard this statement. We've heard this 10 times. So I think I would like to just let the record reflect that in answer to the question, are you refusing to answer the questions, Ms. De La Cruz? Are you refusing to answer the questions? Ms. De La Cruz read her statement of objection. And then going to the next part of your statement of objection, where you say that subject area falls outside the scope of your official duties. Which subject areas do you believe fall outside of the scope of your official duties, according to that subpoena?
I, Francis De La Cruz, hereby object to the subpoena served on me today, November 16 at 12:42 p.m., less than 1 hour ago, because of the following. 1, the subpoena must comply with 1 CMC Section 1302.
Thank you, Ms. De La Cruz. May I direct the question to her counsel then? Ms. Alapuzu, which subject areas do you believe are listed in the subpoena that fall outside the scope of Ms. De La Cruz's official duties?
May I respond, Madam Chairwoman?
Recognize Council Alapuzo.
Thank you. Ms. Sablon, Representative Sablon, this subpoena was served on us at 12:42. We were commanded to be here at 1:30. That left us with less than 1 hour to properly review all the additional questions that was in the subpoena. So at this time, I'm not ready to answer that question. We made the
I
best
believe
of
there are
what we.
just
I'm
three
sorry.
questions.
May I finish? May I finish my response? May I finish my response? May I finish my
I would
response?
expect for you to answer the question,
I
Ms.
am
Alapuzo.
answering the question.
Okay, so which subject areas do you believe fall outside the scope of Ms. De La Cruz's official duties?
At this time, that is the objection that she is lodging. I am not prepared to answer that question right now until I have been given ample opportunity in order to research and advise her of her rights and what she can and cannot do.
Okay, so let the record reflect then, Madam Chair and colleagues, that even Ms. De La Cruz's counsel cannot say at this time which subject areas fall outside the scope of Ms. De La Cruz's official duties.
And
Although
even though I am unable to advise her, she is still lodging the objection.
If there are subject areas that fall outside the scope of Ms. De La Cruz's official duties, then I don't see the legal basis for invoking immunity or executive privilege as to those areas. I yield at the time, Madam Chair.
Thank you, Representative Sablon. I recognize Representative Edwin Probst.
I just have a question for Ms. De La Cruz. Ms. De La Cruz, I understand your loyalty to the governor. Obviously, he's your boss, he's your employer. But are you willing to risk prison for Governor Ralph Torres? Thank you.
I, Francis De La Cruz, hereby object to the subpoena served on me today, November 16.
Thank you.
Short recess. Thank you, everyone. We are back from recess. It is now 2:50 p.m. We have asked simple questions of the witness this afternoon, Ms. Frances de la Cruz, and all she has done is repeated a statement that was prepared for her. At this point, we would like to excuse Ms. de la Cruz until further notice. This in no way releases you from the subpoena that was served upon you today. And we will notify you of your next appearance date. The witness is hereby excused until further notice.
Thank you, Madam Chairwoman.
Okay. Thank you, Madam Chairman.
Thank you, Councilor Puzo and Mr. Burnbrick. Thank you, Ms. De La Cruz. Thank you, everyone. We have excused Ms. Frances de la Cruz this afternoon since we were not able to move forward with any questions as simple as asking her name and position. So we have notified Ms. Frances de la Cruz that she is still subject to the subpoena that was issued on October 8th and November 16th this afternoon. She has repeatedly read a statement to object to the subpoena and this investigation in particular as well. And so I do want to make a statement that, you know, the governor has told the press time and time again that he is willing to answer our questions. He even presumed to say he was giving us a deadline to give him questions in writing, but at the same time, his attorneys use every trick in the book to delay and drag this on, such as the example we saw today. Ms. De La Cruz was subpoenaed to appear weeks ago. Out of respect for the executive branch, we generously accommodated her with the option to give us information in writing, but the governor's attorneys have counseled again and again to stonewall and object to these hearings. They have claimed privileges and immunities with no legal basis, and they have even threatened to sue the members of this committee if we enforce our lawful subpoenas. We are a separate and co-equal branch of the government. Article 2, Section 14 of the NMI Constitution says that each house may compel the attendance and testimony of witnesses before the House or its committees. We will not be stymied or intimidated, and we will get to the bottom of this. Today was a good example. There were two attorneys who came with Ms. De La Cruz. Now they've upped the ante in order to prevent Ms. De La Cruz from testifying before this committee. And at this time, I will recognize any of the members if they would like to make statements. I recognize Representative Ed Probst.
Thank you, thank you, Madam Chair. I just want to express how sorry I am to Ms. Frances de la Cruz for the governor essentially being willing to throw her under the bus, to allow her to be a pawn in an investigation that has nothing to do with her whatsoever, except for her testimonials and information that she can provide. Once again, Madam Chair and colleagues and those listening, the governor has repeatedly stated in bravado, I have nothing to hide. He has also insulted this body, complaining about the timeline, that it's taking too long, that it needs to be moved up, that time is costing us. And when he talks about cost, where is his concern when he hired an attorney from DC, Washington, DC, who isn't even licensed to practice here, for $150,000 charged to our taxpayers, and an additional $50,000 to David Baines and Associates? $200,000 worth of legal advisors, counsels for the governor, including his own legal counsel, Gil Burnbrick, and he states that he has nothing to hide. Who hires $200,000 worth of lawyers when he has nothing to hide? Only somebody who has plenty to hide. I find it deplorable and shocking that he would be willing to put Ms. de la Cruz in harm's way, to face contempt charges, to be an uncooperating witness today, to not even answer a simple question by our vice speaker or vice chairman of JGO. What is your name? Sorry. Please state your name, your full name and position for the record. Not even that could be answered today. Nothing that we asked today. But is this anything new to this body? Just look at the witnesses that we have had in our past. Their reluctance to cooperate in an investigation of the governor. The one witness, the brightest point of it, was the lieutenant governor, Arnold Palacios. If anybody is going to claim immunity, it should be the lieutenant governor. He's the right-hand man. He was the right-hand man for the governor until he said too much. This is too much. And he found a conscience, and his clear conscience dictated that he could not be a part of this. But through his courage, he came in and surprised us. He didn't come with a legal counsel. The lieutenant governor came in and spoke the truth. Something we have been craving and asking for. If every single witness answered that way, there wouldn't be delays. We would be moving expeditiously. But we've seen scheduling conflicts and all kinds of excuses, everything else under the sun. And today, Ms. de la Cruz can't even answer or state her full name and position for the record. And they had a legal counsel, Gil Burnbrick, who was present today to remind her from the office of the governor not to say a word. What other reason would the counsel Gil Burnbrick be here today if not for that? Did he answer questions? No. She had a legal counsel today, Miss Viola Alapuzo. And we are witnessing bad faith when we are told certain things and then we get shafted. shafted. At 1:01 in the morning, the JGO chairwoman gets a letter objecting to testifying today, objecting to showing up. And then surprise, surprise, we happen to issue a second subpoena because one is not enough. This governor has made a mockery, not just out of this legislature, not just out of the JGO, but out of the entire Commonwealth. He rules because rules do not apply to the governor. He has opted to be the king, not the governor. And at the sacrifice of somebody that has worked for him faithfully, a good governor, an honest governor who has nothing to hide would say, you know what? Go and answer the questions. Don't worry about it. Just be truthful. Answer whatever you need to answer. I have nothing to hide. That isn't the case that we saw today. And the problem with this is that somebody, a good-hearted person like Ms. De La Cruz, is going to suffer the consequences because of the governor's refusal to cooperate. That is upsetting. And that's shameful and deplorable that he's willing to sacrifice her to save himself. I find that morally reprehensible. This is an emotional time right now because we have sought answers that we cannot get. They are trying to out-lawyer us because we have two legal counsels who provided it to us, thank God, great legal counsels, but they also have other duties because they have to serve 20 of us in the House. This is not their sole duty. While the governor gets to choose whatever lawyer he wants in the entire world and picks a DC fancy lawyer at $150,000. No one finds this wrong? Everybody finds this okay? That we have non-cooperating witnesses? It is at this point that we must ask, what is the role or what is our ability to do our jobs if we have witnesses not willing to testify? What? If we have none, then we have no teeth. Madam Chair, I'm sorry, and colleagues, that the disrespect that we all see is clearly caused by one person, the governor. Never in our history have we seen witnesses come up and have legal counsels by their side at all times to answer simple questions and then be told not to cooperate, not to answer the questions. Very disappointing. My heart goes out to Ms. De La Cruz, her family, and I believe the governor owes her an apology. Thank you, Madam Chair and colleagues.
Thank you, Representative Probst. Are there any members who wish to make comments at this time?
I'd like to make a statement, Madam Chair.
Recognize Representative Christina Sablon.
Thank you. So the record shows from today's proceeding, Madam Chair, that Ms. De La Cruz failed to appear this morning as commanded by this committee pursuant to a subpoena she received weeks ago. And then when she did appear this afternoon, pursuant to a second subpoena, she refused to answer questions and merely read a prepared statement of objection. Even as Representative Probst noted, as we all heard, the most simple questions repeated over and over: what is your name and position? refused to answer even those basic questions. And when pressed, would not or could not explain even the part of her objection that cites that there are subjects outside the scope of her official duties. Would not or could not explain why any of those subjects then would be any reasonable basis to invoke immunity or executive privilege, why that should apply. Her legal counsel could not explain that either. This is unacceptable and unlawful conduct. And as patient and accommodating as this body has been, we cannot let this conduct slide without consequences. Because what precedent does this set, Madam Chair and colleagues, for other witnesses in this investigation or in future investigations? If actions that are in clear contempt of this legislature, actions that show clear disrespect and willful delay or obstruction of a legislative investigation are allowed to simply be let go without any sort of action or sanction, any consequence, particularly if the subject of the investigation, the governor himself no less, is involved and implicated in that delay and obstruction and instructions to government employees not to operate. I think at this juncture, we have no other choice but to respond in accordance with the law and hold Ms. Dela Cruz in contempt. I yield, Madam Chair.
Thank you, Representative Saplan. Are there any other comments from any other members? If there are none, we will move forward. I recognize Representative Richard Lizama.
Thank you, Chairwoman. It seems like it's the same pattern that we have on every witness that we provide a subpoena to come into the chamber. It seems like they practice, not to say anything. The governor, all the time, he has nothing to hide. I believe he should encourage the witnesses, just like what Rep. Prop said, to come in here and just tell the truth, nothing but the truth. It's a simple question, and it's not a question engaging their integrity. It's basically just saying, well, it is engaging their integrity, but not to be arrested or be charged, because this is not about the individuals that we brought into our chamber. This is about our governor. So I would like to move in contempt. Should I?
I recognize the Vice Chair, Boss Jonathan Apto.
Thank you, Madam Chair. Just a question to the mover, Representative Zama. Your motion, you're making a motion to, please?
Yes, Vice Chairman, I move to hold Ms. Frances de la Cruz in contempt and report to the Speaker for certification to the Attorney General. Frances de la Cruz is the Executive Assistant to the Governor. So I move.
Thank you, Representative Lizama. A motion has been made to hold Ms. Dela Cruz in contempt and report to the Speaker for certification to the Attorney General, and has been seconded. Are there any discussions on the motion? If there are none, all those in favor, please, or I'm sorry, I would like to go on the record and have this be a roll call vote. I will recognize Cam Nicholas, the legislative assistant, for the roll call.
Representative Blas Jonathan BJT Atta.
Yes.
Representative Richard T. Lizama.
Yes.
Representative Donald M. Manglonia.
Yes.
Representative Edwin K. Probst.
Yes.
Representative Selena R. Babalta.
Yes.
Madam Chair, 5 members present voted yes and 2 members absent.
Thank you, Cam. At this time, there is a unanimous vote to hold Ms. Dela Cruz in contempt and report to the speaker for further certification to the Attorney General. That motion by unanimous vote it carries. At this time, I would like to go on recess until Thursday at 10:30 a.m. That would be Thursday, November 16th at 10:30 a.m. This meeting is hereby in recess.